My name is Bernard R. McConnon III, and I'm the founder and CEO of Democracy Data and Communications, commonly referred to as DDC. Before I begin, I wish to note for the record that I'm appearing here voluntarily at the request of this committee. DDC is a leading provider of grassroots impact database management services, website and communications programs to the public affairs market. Among our products is Democracy Direct, a proprietary relational database management application which we offer under an application service provider model. The Democracy Direct system allows clients to catalog an immense amount of information about their stakeholders and other assets, and then search, sort, and segment that information in complex ways to facilitate more effective and efficient communication efforts on legislative and regulatory issues. Our client list includes a majority of the Fortune 100, many of the largest trade and professional associations, and several of the country's largest membership organizations as well. In 2001, DDC was hired by Capital Campaign Strategies and later by Scanlon Gould to first provide data warehousing and then online database management services for several Indian tribes, including the Louisiana Coushatta. I understand from your staff that the committee has some questions regarding our contract with CCS, and I'm happy to answer them at this time.
Thank you very much. Mr. Cathcart.
Good morning, Mr. Chairman, Senator Dorgan. I'm joined here today by Charlie Leeper, an attorney with Spriggs & Hollingsworth. Since at least as early as September 2004, I've been cooperating with the committee staff investigators by answering questions and responding to inquiries regarding work performed by my former employer, Capital Campaign Strategies, and its affiliated companies, collectively CCS, for and on behalf of various tribal clients. For example, on September 21st, 2004, I was interviewed by committee investigators Pablo Carrillo and Catherine Rossi. On that occasion, I responded to each and every question posed by Mr. Carrillo and Ms. Rossi. Those questions pertain to numerous aspects of the work performed by CCS for its tribal clients, including the Saginaw Chippewa Indian Tribe of Michigan, the Agua Caliente Band of Cahuilla Indians, and the Tigua Indians of Isleta del Sur Pueblo, as well as various other matters. Similarly, on November 4, 2004, I was interviewed by committee investigators Pablo Carrillo, Brian Parker, and Catherine Rossi. On that occasion, I responded to each and every question posed by Mr. Carrillo and Parker and by Ms. Rossi. Those questions pertain to numerous aspects of the work performed by CCS for its tribal clients, principally the Tigua Indians of Isleta del Sur Pueblo, as well as to various other matters. On May 5, 2005, I was once again interviewed by committee investigators Pablo Carrillo, Brian Parker, and Catherine Rossi. On that occasion, I responded to each and every question posed by Mr. Carrillo and Parker and by Ms. Rossi. Those questions pertain to numerous aspects of the work performed by CCS for its tribal clients, including the Mississippi Band of Choctaw Indians and the Saginaw Chippewa Indian Tribe of Michigan, as well as to various other matters. In all, I estimate that I've submitted to approximately 15 hours of questioning. Furthermore, I've responded verbally and in writing through counsel to all follow-up inquiries posed by committee counsel. I've done this as a result of my respect for this committee and its objectives. Recently, I was made aware of a request from the committee investigators to make myself available to answer inquiries regarding work that CCS performed for the Coushatta Tribe of Louisiana. Even though I no longer reside in the Washington, D.C. metropolitan area, I offered through my counsel to accommodate this request by traveling to Washington at my own expense to appear for a further interview on Saturday, October 15, 2005, and at that time to answer any and all questions the committee investigators may have regarding the Coushatta Tribe of Louisiana. I'm informed that the committee investigators have rejected my offer to appear for an interview and instead insisted that I give a deposition where the questions and answers will be transcribed by a court reporter. Through my counsel, I declined to provide a deposition, but I'm appearing voluntarily at this hearing today. I'm aware that the U.S. Department of Justice is conducting a criminal investigation of events relating to lobbying and other professional services rendered on behalf of various Native American groups, including certain services provided by CCS for and on behalf of the tribal clients identified above. I understand that as a former CCS employee, I'm a witness to certain events within the scope of the DOJ investigation, and I'm in possession of information that could further the objectives of that investigation. I further understand that it may be inconsistent with those objectives for me to submit at this time to a deposition or transcribed questioning conducted by individuals other than DOJ investigators. With all respect, such a deposition or transcribed questioning by the committee investigators may give rise to ambiguous circumstances that could jeopardize my position as a witness in that ongoing investigation. Given these circumstances, and having considered the United States Supreme Court ruling in Ohio v. Reiner that the Fifth Amendment of the United States Constitution protects the innocent who might be ensnared by ambiguous circumstances, I accept the advice of my legal counsel and respectfully and regretfully will decline to answer questions at any hearing, deposition, or transcribed interview conducted by the committee and or its staff on the basis of the rights guaranteed to me by the Fifth Amendment.
Thank you, Mr. Cathcart. My understanding is that your response to any question from the committee at this time would be assertion of your legitimate Fifth Amendment rights. Is that
That's
correct?
correct.
Thank you.